Now we'd like to commence the first session of our conference under the topic of coastal state jurisdiction in the territorial sea. And for this, Her Excellency Maria Teresa Infante Coffey, Judge of the International Tribunal for the Law of the Sea, will moderate this session. Judge Infante Coffey, now the floor is yours.
Good morning, Excellencies, professors, distinguished participants. It is a real honor to moderate this panel, which is devoted to the coastal state jurisdiction in the territorial sea. As the title suggests, the focus is on jurisdiction and its connections with sovereignty and its limits. There are strong underpinnings in international law of the subject. Questions relating to people on board foreign flagged vessels from the perspective of their protection will also be analyzed in the panel. The powers of coastal states is among the most traditional chapters of the law of the sea, and this panel will certainly provide a better view of the current situation and will anticipate features of future developments in a highly dynamic area. Among the aspects to consider in these scenarios, there are trends to include the perspective of people at sea, from the balance of interest and rights between coastal states and foreign vessels, to the question of jurisdiction to adopt measures in certain situations, what raises, among other issues, the nature and scope of the innocent passage issue. Articles 17 to 20 of UNCLOS could be read as established law. They reflect the current framework of the territorial sea regime. The question for the panel is whether there are new insights to illuminate their purposes and object. The panel is integrated by the following speakers and discussants. Professor Tara Davenport from the National University of Singapore, where she's an assistant professor at the Faculty of Law. She's also co-head of the Oceans Law and Policy team at the Center for International Law at the University of Singapore, National University of Singapore, Deputy Director of the Asia Pacific Center for Environmental Law, and member of the Executive Council of the Asian Society of International Law, a member of the editorial board of the Asian Journal of International Law and Ocean Development, and International Law Journal. She studied at the London School of Economics, the National University of Singapore, and Yale Law School. Her research interests are in the law of the sea, including maritime security, submarine cables, deep seabed mining, interactions between climate change and law of the sea and the marine environment. Then Professor Anna Petri, who holds the chair of international law and public law at the University of Basel in Switzerland. She was previously professor at the University of Zurich. She studied at the University of Basel and in Harvard Law School, and is a member of the bar of the Canton of Bern and of the New York State Bar. Her legal experience includes work in private practice, the courts, and the legal division of the International Committee of the Red Cross. She has contributed with many textbooks on the law of the sea, international public law, and criminal law. She has provided expert advice, oral evidence, and legal counsel on maritime-related matters to the government of Switzerland, to NGOs, to the United Kingdom House of Lords, and international organizations. She was also a member of the Swiss delegation to the International Maritime, has been a member of the Swiss delegation to the International Maritime Organization. And what is very important, she was sitting as a judge in the International Tribunal for the Law of the Sea in cases 27 and 29. And she's currently a board member of the Swiss Maritime Law Association and the Swiss Society of International Law, and co-rapporteur of the Committee on Protection of People at Sea of the International Law Association. Mr. Carl Reich, from the Ministry of Foreign Affairs and Trade of New Zealand, is currently Chief International Legal Advisor in the New Zealand Ministry of Foreign Affairs and Trade, and responsible for general international law, trade law, sanctions issues, and environmental law. He has been ambassador to the European Union and NATO, and has had postings in The Hague and Geneva. Before joining the Ministry of Foreign Affairs and Trade, Mr. Rage worked for the New Zealand Attorney General's Department and was a state prosecutor. His studies have been followed at the University of Canterbury and the Victoria University of Wellington in his home country, New Zealand. And Dr. Kim Won-hee from the Korea Institute of Ocean Science and Technology. He's director of the Ocean Law Research Department at the Korea Institute of Ocean Science and Technology. Before joining the institute, he was a senior researcher at the Korea Maritime Institute and the Secretary-in-Chief of the Korea Society of International Law. He was also lecturer at Konkuk University, Women's University, and Korea National Open University. Dr. Kim participated as a legal advisor to the Korean delegations in the 5th session of Intergovernmental Conference on the BBNJ Agreement and the meeting of state parties to UNCLOS. He has recently published studies such as reconceptualization of the critical date in territorial disputes in the light of the law of evidence before the international courts and tribunals, United Nations ocean governance and recent practice of the Republic of Korea on the law of the sea, as well as the import of hybrid activities in the South China Sea. With these presentations, now I open the panel. Panelists will have 30 minutes each, and they will have discussions of 15 minutes each. And then we will leave 10 minutes for general questions and comments. So with this, Tara, the time is yours. Thank you.
Good morning, distinguished guests. Excuse me. I am truly honored to be here today in such a distinguished panel and such a distinguished conference, and would like to express my heartfelt thanks to the Ministry of Foreign Affairs, the Korean Society of International Law, and the International Tribunal for the Law of the Sea for the invitation and wonderful arrangements. Today, I'm talking about reconceptualizing coastal state sovereignty in the territorial sea through the lens of transit submarine cables. Two disclaimers before I begin my presentation. Firstly, my ideas on this are very tentative, very preliminary, still evolving. And secondly, I'm here in my personal capacity, and in no way does this represent the views of Singapore or the Center of International Law or the National University of Singapore. Right, so I'm going to go straight to the problem. There are generally two types of submarine cables: submarine fiber optic cables, which traverse the ocean floor, connecting continents and countries, and which facilitate the transmission of data, providing internet-related services that we take for granted every day, and more importantly, that contribute significantly to the economic development of states. The second type of submarine cable are submarine power cables, which facilitate the transmission of electricity. While not as extensive as submarine fiber optic cables, you can see from this chart that their use has been steadily increasing, especially as the world turns to renewable energy in the quest to get to net zero emissions. The legal regime governing submarine cables, of course, is set out in the 1982 UN Convention on the Law of the Sea, which purported to establish a legal order for the oceans which will facilitate international communications, which I've highlighted there in the preamble. Excuse me. The provisions in UNCLOS on submarine cables are based on older treaties, such as the 1884 Convention on the Protection of Submarine Telegraph Cables and the 1958 Geneva Conventions on the continental shelf and on the high seas. When UNCLOS was concluded in 1982, submarine cables were not extensively relied upon. You can see in 1982, there were 6 submarine fiber optic cables, 17 submarine power cables. This year, there are 559 submarine fiber optic cables and approximately 450 submarine power cables. These provide, submarine fiber optic cables provide 99% of global telecommunications, and of course, power cables are providing an increasing proportion of our energy needs, especially as we turn to renewable energy. While UNCLOS affirmed that all states had the freedom to lay and repair cables in the exclusive economic zone and the continental shelf, high seas, and deep seabed, of course, subject to the various obligations and rights in those zones, in areas subject to sovereignty, such as the territorial sea, the straits used for international navigation, and archipelagic waters, the right to lay and repair submarine cables was deemed to be subject to coastal state or archipelagic sovereignty. This leads us to the subject of this presentation, finally, namely submarine cables that transit areas under sovereignty without making landfall, which I will describe as transit submarine cables. I put here some examples on the basis, on the perspective of Singapore, which is a global hub for submarine fiber optic cables, but being a geographically disadvantaged state, several of these cables have to pass through the territorial seas of Malaysia and archipelagic waters of Indonesia. In the second image, you will see the proposed Sun cable, which intends to import low-carbon electricity from Australia to Singapore. But it is subject, of course, to the regulatory approval of Indonesian authorities as the cable passes through their waters. Singapore is one such example, but there are other examples of transit submarine cables passing through the territorial sea of coastal states without making landfall, particularly given the extensive use and reliance on submarine cables. So I guess the problem that I've been contemplating, or the issue that I've been contemplating, is of course the assumption is that such transit submarine cables are subject to coastal state sovereignty under UNCLOS. Pursuant to such sovereignty, it is generally accepted that coastal states can refuse consent for deployment of such cables, or refuse consent for the repair of existing cables, or can impose permitting requirements or cabotage requirements. Coastal states have a significant degree of leverage over the deployment and repair of such cables, and there is an assumption that there is a little recourse to challenge such regulations. The question, which is really a hypothetical scenario, which I want to explore, is do coastal states have obligations to states that are connected to submarine cables that transit the coastal state's territorial sea? This is, again, as I said, a very much hypothetical question, but I thought it would be a useful lens through which to interrogate a broader question of the limits of coastal state sovereignty in the territorial sea. Transit submarine cables pose a unique challenge in that they do not directly benefit the coastal state, but their neighboring states. But they also raise similar concerns that coastal states would have in their territorial sea in relation to their security and environmental concerns of activities in their territorial sea. I intend to develop my argument by talking about the historical development of coastal state sovereignty, the conception of coastal state sovereignty under the Law of the Sea Convention, the limits that have been developed by UNCLOS courts and tribunals, and then going back to the question and seeing how these arguments can apply to my initial question: do coastal states have obligations to states that are connected to submarine cables that transit the coastal state's territorial sea? Do not be alarmed. I do not intend to start at the 12th century for the development of coastal state sovereignty, but only to start with a general proposition that state sovereignty over territory has evolved over historical and political contexts and has also been heavily contested. There has always been this tension between, I guess I would say, absolutist conceptions of sovereignty, as articulated by Jean Bodin, as this idea of sovereignty is absolute, perpetual, and undivided, to a gradual limitation on sovereignty, which I would say reflects modern conceptions of state sovereignty in the 20th and 21st century. The development of coastal state sovereignty over the territorial sea has a long and complex history, which is closely linked to the development of the nation state. So, of course, the seeds for coastal state sovereignty over the territorial sea can be traced back to the 17th century debates between Grotius and his contemporaries in response to the explosion of colonial, maritime, and trading ambitions of European states. As I'm sure the audience here knows well, Grotius used domestic conceptions of property based on Roman law to argue that the seas were res communis, common property, because it could not be occupied due to its non-rivalrous nature and its susceptibility to universal use. Grotius was using, of course, these arguments to support freedom of navigation and ultimately freedom of trade. But he also acknowledged later on that some parts of the sea near the coast could be occupied and subject to private property, with the caveat that such occupation should not hinder common uses such as navigation, which really did not deprive coastal states of the use or enjoyment of that area. So there were various different theoretical justifications for coastal state rights in the territorial sea between the 17th and 20th century. In the 17th and 18th century, the idea that such waters were the property, right, were owned by the coastal state was prominent. The basis of such ownership would be, for example, again, based on this idea of occupation and control, such as through the 3 nautical mile cannon shot rule, exclusive fishing rights. However, property theories were not able to reconcile ownership with the recognition of the growing rights or the important rights of ships to navigate unimpeded, which became particularly important in the 19th century with the growth in trade, developments in technology, with the steamship, and so forth. Therefore, other theories, such as the jurisdictional theories, which essentially argued that coastal states had certain rights of jurisdiction over the sea, but without owning it, and therefore innocent passage was permitted. But there were also weaknesses with the jurisdictional theories, because it could not account as to why coastal states have exclusive rights to maritime resources or marine resources in the territorial sea. This led to sovereignty theories. Right, sovereignty theories became entrenched, and I put here a quote from Richard Barnes in his book Property and Natural Resources, where property-based claims merge with the exercise of governmental authority. D.P. O'Connell would more acerbically observe that the predatory instincts of states could only be satisfied in the concept of sovereignty, for where sovereignty was lacking, there was doubt about the state's authority to appropriate to itself the riches of the coastal sea and to legislate effectively for foreign ships. So this idea of sovereignty not only entailed jurisdiction, both prescriptive and enforcement, but also this idea of exclusive rights to the resources. In the 20th century, debates about the juridical nature of the territorial sea died down, and very few authors disagreed with the notion that the coastal state had sovereignty, and this was bolstered by developments in state practice. In the Grisbadana case of 1909, the Permanent Court of Arbitration found that that maritime territory constituted an inseparable appurtenance of the land territory, which automatically forms part of ceded territory, presaging the arguments we would see in the continental shelf cases, this idea that it is your sovereignty over your territory that gives you sovereignty over the waters and the continental shelf eventually. The prevailing theory at that time was that the territorial sea depended not on the coastal state's property rights, but that of sovereignty over land territory. In the 1930 Hague Conference, which was the first attempt to codify the law of the sea, the Property Commission noted, it would seem possible to take as a point of departure the proposition that the state possesses sovereignty over a belt of sea around its coasts. This involves possession by the state in the belt of the totality of those rights which constitute sovereignty, so that it is not necessary to specify, for example, that it has legislative authority over all persons, power to make and apply regulations, judicial authority, power to grant concessions, and so forth. Again, in the 1956 ILC draft articles, this conception of coastal state sovereignty didn't really change much. Article 1 of the ILC draft articles said the sovereignty of a state extends to a belt of sea adjacent to its coasts, described as the territorial sea. It went on to say that the Article 1.2, the sovereignty is exercised subject to the conditions prescribed in these articles and by other rules of international law. The commentary noted that paragraph 1 brings out the fact that the rights of the coastal state over the territorial sea does not differ in nature from the rights of sovereignty which the state exercises over other parts of its territory. Again, it also noted this idea that this reference to other rules of international law was because it could not exhaustively state what the limitations to coastal state sovereignty would be. So again, the nature of coastal state sovereignty in the territorial sea was not subject to much discussions during the negotiations of UNCLOS in the third conference on the UN Law of the Sea. Although there was an attempt by Ecuador to provide a detailed list of activities that was to be regulated by the coastal state, including natural resources, energy generation, marine pollution, marine scientific research, artificial islands, and so forth. The primary limitation on coastal state sovereignty in UNCLOS is this obligation not to hamper innocent passage of foreign vessels. Beyond innocent passage, oh, thank you very much. You can tell my voice is going. Excuse me. My apologies for that. Beyond innocent passage, there is uncertainty on coastal state authority to control activities in the territorial sea. A state that wishes to claim otherwise has the burden of proving that other rules of international law restrict the residual authority of a coastal state to regulate a particular activity. Again, this idea, the conception of sovereignty in UNCLOS, right, in comparison to the exclusive economic zone and continental shelf, which is very much seen as zones of shared obligations, shared rights, shared responsibilities, through the mechanisms of due regard, for example, as well as this obligation not to cause unjustifiable interference with the rights and freedoms of other states. This was not present in Part 2 of the Law of the Sea Convention. Again, I come back to one of my favorite jurists, D.P. O'Connell, right, who I think provides a very good conception, or I guess articulation of the conception of sovereignty that underpinned coastal state sovereignty in the Law of the Sea Convention at the time it was negotiated. A state is sovereign over something which it can impose its power over the thing, and the territorial sea is something over which a state can exercise its dominion by force of arms. International law in its present form admits that the territorial sea, without being susceptible of property in the private law sense of the term, is so in the international sense of sovereignty. The result is that the coastal state is sovereign in the coastal seas as it is on dry land, and its sovereignty is a prolongation of its territorial sovereignty. The territorial sea is part of its domain and not simply a part of the vast ocean envisaged in its majestic unity. So this idea, again, that the oceans has always been this space of shared rights and obligations and responsibilities, but this was not so in at least the conception of sovereignty that underpinned the Law of the Sea Convention. But of course, UNCLOS courts and tribunals have tried to, or have attempted to articulate some limits to coastal state sovereignty. In the Chagos Marine Protected Area arbitration in 2015, it noted that Article 2.3 places an obligation on coastal states to exercise their sovereignty subject to the general rules of international law, as opposed to bilateral undertakings. It noted that the ILC considered reference to other rules of international law necessary, as there were certain general rules of international law which were applicable in the matter, as indeed to other topics of international law, such as the principle prohibiting the abuse of rights and generally the law of state responsibility. Article 2.3 requires the United Kingdom to exercise good faith with respect to Mauritius' rights in the territorial sea. Article 56.2 requires the United Kingdom to have due regard for Mauritius' rights in the exclusive economic zone. The tribunal considers these requirements to be, for all intents and purposes, equivalent. And again, I think it's useful to elaborate on this idea of due regard, which the arbitral tribunal articulated. Right? They said that it's not a universal, the due regard obligation does not prescribe a universal rule of conduct. The extent of the regard required by the convention will depend upon the nature of the rights held by Mauritius, their importance, the extent of the anticipated impairment, the nature and importance of the activities contemplated by the United Kingdom, and the availability of alternative approaches. In the majority of cases, this assessment will necessarily involve at least some consultation with the rights-holding state. To me, this is alluding to this idea of proportionality, that your rules and regulations have to be proportional. In the South China Sea arbitration, the arbitral tribunal recognized that traditional fishing rights constituted a vested right, and the tribunal considers the rules of international law on the treatment of vested rights of foreign nationals to fall squarely within the other rules of international law applicable in the territorial sea. The tribunal noted, however, that traditional fishing rights are not absolute or impervious to regulation. Customary international law in this respect does not restrict the coastal state from reasonable regulation. Again, this is sort of a recognition that the territorial sea is also this area of shared rights and obligations in which balancing of interests between states is necessary. In the Dusgit integrity arbitration in 2016, which I think is also very interesting, this concerned the exercise of enforcement jurisdiction by Sao Tome, I'm pronouncing it wrongly, over a vessel that is suspected was committing ship-to-ship transfer in its archipelagic waters. The arbitral tribunal found that in the tribunal's view, when considered together with the prolonged detention of the master and the vessel, the monetary sanctions, and the confiscation of the entire cargo, this cannot be regarded as proportional to the original offense or the interest of ensuring respect for Sao Tome's sovereignty, including Sao Tome's interest in demonstrating that such conduct will not be tolerated in future cases. Excuse me, I'm going to take a drink of water. The disproportionality is such that it renders the cumulative effect of these sanctions incompatible with the responsibilities of a state exercising sovereignty on the basis of Article 49 of the Convention. This, of course, refers to sovereignty in archipelagic waters. The tribunal went on to find that Article 300 of the Convention, which sets out a good faith and abuse of rights obligations, which I'll come to later, it noted that the tribunal is not aware of any prior instance in which another tribunal or court has found a breach of Article 300 of the Convention. There is therefore little guidance as to the legal test that needs to be satisfied. In the present case, the tribunal sees no need to determine a violation of Article 300, given that it has already determined that Article 49.3 has been violated. Again, this alludes to this idea that sovereignty comes with certain responsibilities. A last slide on potential other limits to coastal state sovereignty. Other rules of international law which have not been explicitly dealt with by UNCLOS courts and tribunal. This idea of no harm. A state's sovereign right to use its territory is circumscribed by an obligation not to cause injury to or within another state's territory. This was, of course, recognized in the Islands of Palmer's arbitration. territorial sovereignty has a corollary, a duty, the obligation to protect within the territory the rights of other states, in particular their right to integrity and inviolability. In the Corfu Channel case, every state's obligation not to allow knowingly its territory to be used for acts contrary to the rights of other states. So of course this is manifested most concretely in the obligation not to cause a transboundary environmental harm. And again, this, cases such as the land reclamation case, the South China Sea arbitration, right, the idea of the duty to cooperate puts a restraint on the complete discretion that coastal states have within its territorial sea. There is restraint in what it can do within its territorial sea. It cannot cause harm to other states. Article 300 of the Law of the Sea Convention, state parties shall in good faith assume the obligations under this convention and shall exercise the rights, jurisdiction, and freedoms recognized in the convention in a manner which would not constitute an abuse of rights. So testing the limits, I see I have 6 minutes, I'm making good time. Back to the question, do coastal states have obligations to states that are connected to submarine cables that transit their coastal state's territorial sea? I would like to tentatively and preliminarily argue that the cases that I've discussed so far demonstrates there are limits to sovereignty, underpinned by this conception that even in areas subject to sovereignty, it is still necessary to balance rights and obligations of other states. And this is done through various mechanisms, be it good faith, be it through the idea of proportionality. However, both the Chagos Marine Protected Area Arbitration, as well as the South China Sea Arbitration, was based on this idea of other states had vested rights. There are no such vested rights for states that are connected to transit submarine cables, right? The right to lay and repair a submarine cable in the territorial sea is not recognized in the Law of the Sea Convention. There's a more promising argument that can be made in the Dusgit Integrity Arbitration, right? This idea that the enforcement actions taken by Sao Tome were not proportional to the interest of ensuring respect for Sao Tome's sovereignty under Article 49 of UNCLOS. Could it be argued, for example, that particularly for coastal state regulations for the repair of transit submarine cables, it's very important to do it in a very expeditious manner, that regulations which are excessive do not meet this requirement of proportionality? Is there a general requirement that coastal state sovereignty or coastal state jurisdiction has to be exercised in a proportionate manner that really aims to protect the sovereignty of the coastal state? What about the obligation to ensure that any regulations relating to transit submarine cables do not cause harm to the states connected to the transit submarine cable? Right, this idea that if you don't, in particular, allow repairs or even deployment, you are in some way harming the interests of connected states to the transit submarine cable. The possibility of using Article 300 of UNCLOS, this idea of good faith and abuse of right, is probably not going to be very successful. Courts and tribunals have found that this is not a standalone right and has to be accompanied with breaches of other obligations in the Law of the Sea Convention. So, in conclusion, I would say that while there has been a shift towards viewing the territorial sea and other areas under sovereignty as not the absolute domain of the coastal state and an area of shared rights and responsibilities in which some form of balancing of interests must take place, either through this idea of good faith or proportionality, there is still uncertainty on the limits of coastal state sovereignty, and in turn, the limits of coastal state jurisdiction in relation to activities that do not fall within the innocent passage paradigm. As a matter of lex lata, it is not possible to state with certainty whether coastal states have obligations to states that are connected to submarine cables, although plausible arguments can be made, particularly in relation to proportionality and good faith. UNCLOS was adopted at a time when submarine cables were not in extensive use as they are now. And the question remained as a matter of lex ferenda. And of course, there are many ways in which, there's still the hurdle of how this is going to be done. Whether the interests of all states in communications and energy supply necessitates a rethinking of the laying and repair of transit submarine cables in areas under sovereignty. Perhaps it is time to think about coastal states, of course, being able to regulate the activity, as they do with innocent passage, but in a way that is specifically circumscribed. Again, we go back to this idea that Grotius articulated, this idea of common use, and that even in areas in which there is sovereignty, right, this does not mean that the common use of the oceans can be prohibited. And I will end with that, with exactly 1 minute and 54 seconds. Thank you very much.
Thank you very much, Professor Davenport.